Ladies and gentlemen, thank you for taking the time out to be with us today. A very warm welcome to the third webinar in our 2025 edition of the M&A Academy program. My name is Samir Shah and I'm an M&A partner in Khaitan's corporate M&A group. I would once again like to extend a very warm welcome to all of our audience, whether you're listening to us live or you're viewing a recording on the YouTube platform. This entire M&A Academy program was designed to provide foundational legal knowledge and a very good practical understanding on how M&A transactions and processes are run in India. And therefore, it should be of interest to anybody who's participating in the M&A ecosystem today. For today's topic, our subject is structuring cross-border transactions. And on this slide, we have the agenda for today's program. We will have a panel discussion, which will be followed by Q&A. We've received several questions already from the audience as a part of our registration process. But if you have any questions, please continue to submit them using the facility provided in the webinar portal. You can either address them to a specific panelist or leave it open, and then I will pick one of our experts to address your questions. If we cannot cover all our questions today, we will respond to you offline after email. And in any event, the summary notes of the discussion and a recording of this webinar will be sent to you by email, and the recording will also be uploaded on YouTube. Let me also introduce the topic for today. And as we all know, foreign investment into India is thriving, and many Indian companies are looking to expand and invest into overseas markets. Therefore, both inbound as well as outbound cross-border transactions are significant for both foreign as well as Indian companies. In an increasingly interconnected global economy, cross-border transactions have therefore become a cornerstone of corporate strategy. It could be an acquisition, a joint venture, or a simple investment in your subsidiary, but this requires a very good understanding of how would you navigate the regulatory complexities of international transactions and what are the other legal issues, because these regulatory landscapes change very dynamically and very quickly. Over the next hour or so, we will discuss critical factors to be considered while effectively structuring these transactions to meet your business objectives. Our goal today will be to leave you with practical insights and very actionable takeaways so that you can deal with these challenges and actually capitalize on the opportunities that are presented by such cross-border transactions. Let me introduce our panel today. Everyone who's registered with us would have already received by email a summary of the speakers and their credentials. Therefore, I don't want to spend too much time introducing them, but allow me to say that they are all experts in their own fields and they are the right people to be talking to us today in terms of structuring cross-border M&A transactions. To begin with, we have my partner Moin Ladha, who is a regulatory corporate and M&A partner. He will explain the intricate web of exchange control and foreign investment regulations. We have our tax expert Ritu Shaktawat. She will discuss how to optimize tax efficiency while preserving the broader commercial objective. And we also have our corporate M&A partners Karun Kariyappa and Ashutosh Sharma, who will share deep insights from their otherwise exceptional prior experience in the M&A space. So with that, ladies and gentlemen, let's get started. And why don't we unlock the key considerations for successfully structuring your next cross-border transaction? Let me start with Moin. And Moin, we spoke of foreign investment, overseas investment. Let's start with inbound foreign direct investment. And we have an FDI policy. In your experience, what are the restrictions in that policy that impact deal structuring while structuring transactions for investment in India?
Thank you very much, Samir. So, as we all know that Indian currency is not fully convertible, which is why any foreign exchange transaction is regulated, and one has to follow strictly the rules prescribed. Similarly, for FDI, which is foreign direct investment, because it's the capital account transaction, one has to follow the conditions, and there are two routes that have generally been prescribed. One is the general permission route, and we have the approval route. General permission route are sectors which are less sensitive. For example, manufacturing, let's say. We can also contract manufacturing, single brand retail, subject to conditionalities. Then we have approval route sectors, say pharmaceutical, telecom beyond a certain threshold, real estate, construction. Real estate is a prohibited sector, but construction and development. And the third category is prohibited sectors, which is like gambling, chit funds, lottery business, real estate business, which means buying and selling TDR, which is transferable development rights. So the first step is to analyze which sector are you looking at and which sector is the foreign direct investment coming into. Once we've analyzed that, then we get into specific, aspects like pricing guidelines, which is again the bare minimum fair market value as per the internationally acceptable guidelines, and thereafter reportings and other procedures that are related to be completed. One other aspect which I thought is relevant is that these rules apply both to direct investments as well as downstream investment. And when I say downstream investments, I mean if you have an existing entity in India which is set up by a foreign investor and that entity wants to now invest downward, all the rules I spoke of will become applicable. And there was certain lack of clarity on being able to do deferred structures that also has come through and to be discussed in more detail as we go along. So any entity which is investing from abroad is subject to FDI rules, and any entity which is either controlled by a foreign investor or the shareholding more than 50% is with a foreign investor will also be subject to such restriction and conditions, even though it's otherwise an Indian entity. Back to you, Samir. Yeah.
Thank you, Moin. I think you've set up the scene very well. And Ashutosh, Karun, Moin's given me a lot of questions to come back to you. So deferred, downstream, all of these are absolutely par for course and bread and butter. So Karun, why don't we start with you? And could you help us? Let's continue with the inbound theme. And can you help us with what are the typical structures you've seen in your experience being used for inbound investment into India?
Absolutely, Samir. Look, I think there's fairly straightforward standard structures that we've looked at. These are pretty typical across the world as well. So the first one is obviously a share purchase, where the acquirer essentially purchases the shares of the target from the other shareholders. So this can be either a 100% acquisition or a tranche acquisition, which we'll go into a little bit more in detail later. But this is one of the most straightforward ways for you to acquire an entity in India. The other is also if you're making an investment, then you'll be making an investment by purchasing maybe some of the other shareholders and their shareholding. And this may be minority investors doing investments in minority sort of tranches. The next aspect is, of course, subscribing to new securities. This is, again, typically done in an investment sort of situation where the target itself issues brand new securities in exchange of for funds. But again, since there are swaps that are also envisioned under the FDI sort of policies, there could also be new securities that are issued in exchange for the target securities, right? We've also got asset purchases. Now, the asset purchase is unique in the sense that, every company has got assets and liabilities. Here, the target gets, the acquirer, as a matter of fact, gets to cherry pick what assets it wants to take on without having to bear the risk or the losses, potential losses of any of the liabilities. So for this, you need to actually first incorporate a company in India and then move these assets after you've cherry picked them into the new company that you've formed. Now, this is a bit of a, it's a slightly longer road that you need to follow when you're undertaking an asset acquisition. And that's primarily because you need to obtain third-party consents. You need to go to your lenders. You need to go to your shareholders. You need to go to your customers, landlords. If you have any licenses and authorities, you need to be able to get those approvals, those consents in place before you move those assets across. The next is a business purchase. Now, Indian law recognizes a business purchase as an acquirer acquiring a business as opposed to an entity. So the business has to be a going concern. Now, what does a going concern mean? Essentially, the entire business that you're acquiring needs to operate independently without any third-party sort of intervention. So once you have an identifiable standalone business activity, then you can move this. And again, there are various pros and cons as to why people want to do this. The target itself may be wanting to hive off its entity. The target itself or the acquirer himself wants to acquire only a certain aspect of the target's business, which is why you do a business purchase. Now, the last sort of methodology that's used is obviously a merger or an amalgamation. An amalgamation in the Indian context is, getting the approvals of the courts. Essentially, what it means is you've got two separate, distinct identities, separate, distinct entities, which then merge and become one particular surviving entity. So that you typically go to the courts, you get again shareholders, creditors, all of their approvals. There's advertisements that you need to sort of publish in the newspapers, make sure that there are no people who are coming back and saying that they object to this. So that's also one important element in how acquisitions can be undertaken. One interesting element also is a fast track merger. Now, as I mentioned before, you need to go before the National Company Law Tribunal, which is the jurisdictional authority of the entity that's being acquired, in order to get their approval. In a fast to go through the NCLT process. Now, the way in which this has been envisaged is that there are certain conditionalities that you need to meet with. One is, a merger between two or more small companies, a merger between a holding company and its wholly owned subsidiary. This primarily applies to international holding companies as well as Indian companies who are looking to merge. A merger between two or more startup companies, a merger of a startup company with a small company. Now, interestingly, the merger route is quite topical because there's a lot of reverse flipping which is being undertaken in India at this moment. Historically, about 5 to 10 years ago, a lot of young startup companies had externalized holding structures because they were looking for liquidity, and that was perceived to be the better path of liquidity. Nowadays, the liquidity, as everybody knows, is all in India with the bull run that we've seen. Of course, take aside the entire tariff war that's going on. But in order to do this, the fast track merger is one of those routes that people are contemplating. The wholly owned subsidiary being merged into by the holding company, which is based in either Delaware, Singapore, or other locations. Over to you, Samir. Thank you.
Thank you very much, Karun. I think that's a very great summary. And I've always said that clients keep us third in mind. They wake up by saying we want to make some money. Then they say let's pay as less tax on it as possible. And then hopefully they come to us and say let's do it in a legally compliant manner. So with that, why don't we move to Ritu? And Ritu, Karun very nicely explained the considerations for investing into India. I'm sure treaties and taxation is something that our audience would love to hear about. So if you can take over from that and tell us how do treaties and tax consequences change?
Sure. Thank you, Samir. So non-residents, foreign clients should take a note that yes, tax treaties could be very beneficial in optimizing tax costs payable in India. And Indian law recognizes that if a tax treaty is more beneficial compared to domestic law, then tax treaty prevails. Just to take a couple of examples to explain the impact. So let's say a US company is earning dividends from an Indian company. Under domestic law, the tax rate on dividend income is 20%, but under India-US tax treaty, the tax rate could reduce to 15%. For a UK investor, the tax rate could reduce to 10%. For a Singapore investor, again, the tax rate could reduce to 10%. Mauritius is a unique example where the tax rate could go further down to 5%. So this is how the taxability changes depending on where the investor is investing from. With respect to interest on debt instruments, again, domestic law rates are high. They are 20% or 35%, depending on whether the debt is a rupee currency debt or a foreign currency debt. But under tax treaties, the tax rate on interest income varies between 7.5%, 10%, 15%. Service fee, US is another good example. A US company providing services to an Indian company, domestic law prescribes a rate of 20%, but under India-US tax treaty, the tax rate could even reduce to nil, depending on the nature of services. So this is where the treaty analysis becomes very, very important when you're investing in India or earning any income from India. Now, importantly, when we talk about capital gain at the time of exit, as most of you must be aware, India renegotiated its tax treaties with Singapore, Cyprus, Mauritius, and effective 2017, the capital gain exemption, which used to be available under these treaties, is no longer available. Investments made prior to 2017 are grandfathered, but any investments made post 2017 no longer enjoy the benefit of capital gain tax exemption when the respective shareholder in these jurisdictions sells shares of an Indian company. Currently, under domestic law, the tax rate on capital gain income varies between 12.5% and it could go as high as 35% plus surcharge cess, some additional levies. India-Netherlands treaty continues to be an interesting treaty to look at, where the government has not renegotiated the Netherlands treaty, and Netherlands treaty continues to provide a capital gain tax exemption when a Dutch investor sells shares of an Indian company. There are, of course, certain conditions. Does this mean that all the restructuring with respect to an exit event has gone away? Answer is no. Because if, let's say, you, instead of a share in an Indian company, let's say the investor holds a debt instrument in an Indian company, in that case, these treaties, Mauritius, Singapore, Cyprus, most other treaties are beneficial. If, let's say, instead of a direct sale of an Indian company shares, there's an indirect sale of an Indian company, treaties again are beneficial. And there's an interesting example here where we had this Flipkart Walmart transaction which took place, where Tiger Global Mauritius had sold shares in Flipkart Singapore. Flipkart Singapore held shares in Flipkart India, and therefore the sale, the indirect transfer, was taxable under domestic law, but it was claimed as exempt under the India-Mauritius tax treaty. The tax officer challenged the position. Delhi High Court ruled in favor of Tiger, but currently this favorable ruling has been stayed by the Supreme Court, so it's yet to attain finality. So this is where the treaty eligibility analysis is key to any structuring exercise. And I must add that there are conditions to claim treaty benefits, and the key one is substance in the structure. Earlier, pre-2017, when Indian law did not have anti-abuse rules, treaties did not have anti-abuse conditions. One could just set up an entity, an intermediary holding company in one of these favorable jurisdictions and claim treaty benefits successfully. But now that has changed. Now there needs to be commercial substance in the structures. There need to be very good commercial reasons of setting up a structure in a particular manner in a particular jurisdiction. Just tax saving cannot be the key reason. Otherwise, the tax benefits could be denied. Another mandatory condition is that any non-resident claiming treaty benefits must have a valid tax residency certificate issued by the government of its home jurisdiction. So there could be some time lag, the processing time to get a TRC from the government authorities. That should be planned for when you are looking to earn any income from India or selling an Indian asset and would want to claim treaty benefit. That's how I will sum up the tax treaty considerations. Back to you, Samir.
Thank you, Ritu. And I can't underscore enough that in any transaction, if there's an exiting foreign investor, all of the questions that Ritu articulated, if the seller is well advised, they will anticipate those. But if the seller is not well advised, I think it's critical for the buy side to bring up these questions as a part of their diligence process. Because frankly, if you bring it up later, it's a surprise element. But at the end of the day, the transaction doesn't move forward positively. So on that note, I think diligence is a great place to bring in Ashutosh with all of his expertise. And Ashutosh, in this entire theme of cross-border transactions, in what are the most common legal risks that we see being identified during due diligence in such transactions?
Sure, Samir. Thank you. So, Samir, like you rightly said, diligence is an important aspect, right? It's for smooth deal making, essentially needed for buyers to enter into a transaction with their eyes open, addressing whatever they could have found. In terms of risks, you would usually see, corporate structure related risk, corporate filing related risk. You would see that articles are maybe not updated, or there are plethora of corporate filings required to be made with ROC by Indian companies. Some of them are not up to date. The registers are not maintained properly. So these are some of the basic corporate risks that we usually see. We also see, gaps with respect to intellectual property ownership. You will see founders in the hurry to kind of start up the business have registered their intellectual property in their own name, personal names, rather than giving it to the target. So the value needs to lie with the target where the money is coming in. Issues with trademark. You start up with a brand and it picks up. You never get time to get it trademarked properly or get it registered properly. So those are IP issues that are also there. The contractual issues which come up sometimes, because what happens is you're so used to dealing with your counterparties that you don't really scrutinize the contracts in more detail. So just to give you an example, we were doing a deal where it was an acquisition by a UK company of an Indian manufacturer, and the manufacturer had one vendor which was a significant vendor. It was contributing 20-25% of total revenues, right? And in that contract there was a change in control clause which essentially made us go to the vendor, take the permission before the deal could go through. Right, so these sort of provisions can come up in a contract which may have a termination right or a change in control provision where third party consent or intimation may be required. So those things are there. Then there is your general FEMA compliance. You need to be wary of that also. There are yearly FEMA compliances that need to be done. If you have taken money in at any time, you need to yearly file your performance review. So that needs to be kind of in order. So we need to do a check of whether FCTRS, FCGPRs were filed, and if yes, then whether APRs have been filed year after year or not. We had an issue and it made our life a little difficult. One of the sellers in an acquisition transaction had not filed FCTRS, and we had to go through the entire compounding route, get it done before the deal could progress. So these are sort of things that one need to be mindful of, and these are things that we see when we do the diligence. I also wanted to kind of talk about PN3 a bit because it's often overlooked. People don't realize that PN3, which sort of places a restriction on taking money from someone who's, has a beneficial owner in country sharing land border with India, that also applies to indirect beneficial ownership, right? So we had an issue where, one of the PE funds had a very, very minuscule amount of LP sitting out of China, and that caused an issue for us because we had to go to the government to seek an approval. So yeah, diligence is important. Very, very common issues. They may seem small in the beginning, but they do have potential to delay or derail the deal. So yeah, these are the some of the things that I thought we should bring it up, Samir.
Perfect. And really a failed deal or a slow deal or a deal that doesn't achieve both parties' objectives is really not helpful. And I'm glad you raised the point of PN3 because that was really going to be my next question. And who better than Moin to address that, given how he's been leading the charge on policy advocacy as well as so many approvals that I know we as a firm have been able to get. So Moin, this entire PN3 construct, this was obviously introduced a few years back. But what exactly is the issue? And more importantly, in your experience, what are the solutions? What are the workarounds to this issue?
I think, I'll start by reminding everyone of my first response where I spoke of different categories of investments into India. So we spoke of general permission, that's automatic route and approval route. PN3 is a press note that was notified in April 2020, and what it said is that irrespective of whatever route you're in or whatever sector you're investing in, whether it's a general permission sector or automatic route, an additional approval requirement that becomes applicable is under this press note if the investors or beneficial owner is situated in a bordering nation. So this is the, I'm emphasizing on that term. So it could be either a beneficial owner who's a citizen, a resident, or an entity or a fund that is headquartered in that particular bordering nation. Now, what that really has meant, and then there is no threshold prescribed for what level of beneficial ownership, and as Ashutosh mentioned, even lower level or very minimal holdings also, especially in the cases of funds and LPs, where limited partners, it has been challenged and questioned. So, before we go to the solutions, this becomes applicable when you're doing a direct investment into India, as well as in global deals where it is often overlooked, where there is an India connection really. So one of the most straight and clean and easiest solution is the direct government approval. You approach for a government approval. It's a two-step process. It's the first step is getting a security clearance from the Ministry of Home Affairs, and then it moves to the relevant department, which is the industry you're making the investment into. The government looks at a few things: who's the beneficial owner, whether there are state-owned enterprises who are there, and really speaking, what's the contribution it will do to the sector, whether it will bring in new technology, bring in new sort of, create employment opportunities and all of those things. And we've seen quite a few, dozens of approvals in different sectors across, bordering nations. So primarily Hong Kong, China, other sector, investors we are seeing being, impacted by this. The second option that really is available is looking at your structure and finding out where is the connection from bordering nation and where is the India connection. And depending on the relevance of either of them, either you disconnect India entirely from the structure before you're doing a global deal, or you restructure and get your bordering nation investors out of the structure. So then this really sort of mitigates the requirement for an approval, because you no longer either have India connection or you don't have shareholders from these sort of bordering nations. What we've seen is that this more stricter approach is being adopted in regulated sectors. Let's say for sectors which are otherwise partly approval driven, partly automatic. We would say telecom for 49% you could do, pharma 74%. So therefore, when you go to take an approval, a more stricter approach has been taken. So to sum up, one has to be very careful in their diligence, in their checks, and any investments which have an India connection or any beneficial owners from these bordering nations. That being said, the future and the outcome of this is really going to depend on how the geopolitical issues between India and the bordering nation China at least gets addressed, because that's the level at which we will then expect a more clarity on what's beneficial ownership. And we're already seeing certain sectors, certain type of private equity investors are getting a more fast track treatment when they're making in practice when they're seeking these approvals. So depending on how the governments and the diplomatic relations change, we would hopefully see more traction and clarity around this approval requirement.
Great. And clearly, I think the government to government engagement is very important. And what I'd like to do is I'd like to bring in Ritu. And Ritu, why don't we talk about another issue which has really been plaguing, and this is bipartisan, right? And today the word of the day is bipartisan. I'm going to borrow from the talk of tariffs that Karun also brought in. We've spoken too much about inbound investments. But the one issue which plagues inbound and outbound investments, and as a substantive government to government engagement, is transfer pricing. So, when you're looking at structuring cross border investments, what are the issues from a transfer pricing perspective you see clients most concerned about? And particularly, how do they assess that when it comes to diligencing the company and its practices?
Sure. Thanks, Amir. So, when we talk about transfer pricing in an Indian context, one should understand that Indian transfer pricing regime is quite comprehensive. There are detailed documentation requirements, filing obligations, and non-compliance could lead to penalties and adverse outcomes, additions to income, disregarding expenses, etc. And transfer pricing rules apply to related party transactions where at least one of the transacting entities is a non-resident or a foreign entity. Now, splitting the discussion in two parts, so let's talk more in the context of a transaction. In case of a transaction, it's important to understand that there are certain circumstances prescribed under law under which even a third party transaction could be deemed as a controlled transaction, attracting transfer pricing provisions, arm's length pricing requirements, etc. And it's more relevant where, let's say, an India leg of the transaction is happening pursuant to a larger global deal. So taking an example, let's say there is a US selling entity selling its global IT services vertical to another US buyer. Both buyer and seller have local subsidiaries in India. And the India leg of the transaction, let's say the delivery teams in India, assets in India, they move locally between the India subsidiary of the seller to India subsidiary of the buyer. Now here on the face of it, the local transaction in India is also a third party transaction and therefore should not be subject to transfer pricing. But when we look at the deeming rules, the rules say that if the terms of a third party transaction are determined by or influenced by affiliates of the transacting entities, then this transaction is deemed as a controlled transaction, and government would want that such transactions are also done at fair value supported by valuations. Now, in global deals, India legs, or any other jurisdiction, the local entities would not typically participate in negotiations. Everything is decided, agreed at the global level, and in the respective local jurisdictions, it may just be implementation of what is already agreed. So, therefore, this is a classic case where such deeming rules could become relevant, and what that means is one needs to get valuations in place. There's additional paperwork and needs to ensure that arm's length or a fair value is allocated to the India leg of the transaction. So that's increasingly relevant as we see larger global deals happening within India leg. Now coming to the acquisition specific transfer pricing aspects. So when you're acquiring a business in India, as part of the due diligence review, it's very important to check whether the Indian entity has been complying with transfer pricing requirements. Does it have proper benchmarking study on its files to support the margins charged or the prices charged on intra-group transactions? Has it been making annual transfer pricing filings? Because we do notice when we do such reviews, we do note that Indian companies sometimes lack in ensuring that there is proper transfer pricing documentation on the files. And like any other jurisdiction in India also, transfer pricing is one of the most litigated areas of tax laws. And on a going forward basis also, if as part of the due diligence review, buyer identifies that there are any risks, basis any positions taken by the company, then you would want to negotiate the right package of reps, warranties, specific indemnities, value adjustments if the nature of risk is such. And on a go forward basis, if anything needs to be revisited, then you will have to assess whether that impacts any historical positions of the company. Back to you, Samir.
Great. No, you're right. It's first. It comes first to mind when you talk about tax compliances and mitigating risk. So now that we've discussed inbound, and transfer pricing obviously cuts both ways. It covers inbound and outbound. Maybe why don't we move towards the outbound side of it? And I'd love to bring in Karun, particularly with his experience of having worked on so many global transactions. So Karun, when it comes to overseas investment by Indian companies, what are the various regulatory considerations that you would advise our clients or listeners to bear in mind when planning such an overseas investment?
A great question, Samir. Being based in Qatar's Singapore office, I'm at a unique vantage point where I get to see quite a significant amount of these types of transactions. Look, I think the ODI, overseas direct investment regulations that came out have, brought in much needed clarity in terms of how Indian entities may invest overseas. So first off, you need to understand who is a foreign entity, right? So foreign entity is an entity formed, registered, or incorporated outside of India. So that basically means you have limited liability companies, limited liability partnerships, where the liability of its members are clear and is limited. Those are the sorts of entities that you could invest in. Now, when it comes to overseas direct investment, what does it mean? Investments by way of acquisition of unlisted equity of a foreign entity is one. Investments in 10% or more of the paid up capital of a listed foreign entity, that's two. Investment with control, where the investment is less than 10% of the paid up capital of the listed foreign entity. Now, this is important. What does control really mean? So the right to appoint a majority of directors, you have the right to control management, to determine policy decisions. You have a voting agreement which entitles you to vote in excess of 10%. These are all the sort of definitions of control. Thus, just to summarize, the following investments are covered under overseas direct investments. For unlisted securities, it's investment in even a single share of an unlisted foreign entity. It's subscription to the memorandum of association of that entity, which means setup costs. And then when it comes to listed entities, it's investments of 10% or more in the equity capital of such listed entities, or investments of less than 10% in such listed foreign entity where there is control. Now, there's also the other aspect, which is overseas portfolio investments. So what are the sorts of securities that you can invest in through overseas portfolio investments? is basically investments other than ODI in foreign securities. One caveat though, OPI does not include investments of any unlisted debt instruments or any security issued by a person resident in India other than those located in the IFSC, which is the International Financial Services Center, which is based in India. So essentially, OPIs include investments of less than 10% in equity capital of listed foreign entities without control. Now, there are also financial commitment limits that have been enshrined in the regulations. As far as overseas direct investments concerned, you cannot put in more than 400% of the net worth or 4 times the company's net worth based on its last, this is from the investing entity, based on its last audited financials. From an overseas OPI perspective, it's not more than 50% or 0.5 times its net worth. The other element to keep in mind is pricing guidelines. Any issue of shares or transfer of shares of a foreign entity, especially where it's a resident Indian who is the shareholder and he's transferring to another resident Indian, or from a non-resident shareholder to a resident Indian, you need to make sure that these prices are determined on an arm's length basis and they're supported by a valuation report prepared per internationally accepted pricing methodologies. The other important element that the ODI rules actually came out with, which clarified, was share swaps. Share swaps are now permitted. Initially, there was a little bit of confusion as to whether primary shares were entitled to be swapped, especially in the de-SPAC sort of situation a couple of years ago, which was very interesting. A lot of companies, especially young startups, set up holding structures overseas primarily to explore these de-SPAC situations. Now, you don't need the holding company in overseas jurisdictions for you to be able to do a direct swap of your securities. So those are the sort of key elements from an overseas direct investment perspective that Indian companies are able to pursue.
Understood. No, so that's a very, very good summary. And to all our listeners, we've now spoken of a broader philosophical level discussion on foreign direct investment. What are the various structures, transfer pricing, tax treaties? I was thinking we'd rather now get into a little bit more of a deep dive in detail. So why don't we start with Moin again? Moin, from a Reserve Bank of India perspective or a Securities and Exchange Board of India perspective, focus on what are the approvals that are relevant to a cross-border transaction of this nature. When you're on mute.
Sorry, hi, thank you, Samir. I'll now focus on approvals that are now beyond sector related approvals. So just to give you an example, now Karun mentioned about Karun and Ashutosh both mentioned about fast track mergers, and fast track mergers. This was a circular the government issued where there was now merger is possible of your subsidiary abroad back into India inbound without the involvement of the tribunal. Which essentially, and the reference in that circular was to an approval from Reserve Bank. Now, though there is a general permission available and there's a deemed approval conditionality given, because the reference was to an approval, we had to go and seek an approval, and it took us, and unfortunately, we were able to complete the entire fast track merger in about 45 days. So that was quite a quick timeline, really, including the RBI approval. Then we spoke of ODI. We spoke of ODI and the limit of 400%. But that is the general available limit that you have, but certain sectors have sector guidelines. So let's take an example of non-banking financial companies, core investment companies. So non-banking financial companies, for example, these are licensed by Reserve Bank of India, and therefore one has to go back and look at the Reserve Bank norms. And that lowers the limit to 100% of the net owned fund and has a single entity exposure limit of 15%. So essentially, while as a manufacturing or trading entity, I was able to do 4x, here I'm only able to do 15% into a single entity abroad. And if I want to cross any of these thresholds, I will need to go back and take an approval really from the government of India. And then we speak. Let's also talk about swaps. When we are doing swaps, there was a lack of clarity about how primary swaps and secondary swaps, about how primary and secondary swaps would not work. Now swaps has been mentioned as a type of mode of consideration, and therefore both for foreign direct investment as well as investments overseas, we are able to now implement it under the general permission. Earlier, we were seeking separate approvals, really. And another thing that's very important is to check what is the sector your target or your Indian company is operating in. Because let's say you're licensed by a Securities Exchange Board of India. So we just completed a larger global transaction where we had about 8 or 9 licenses across Reserve Bank and Securities Exchange Board of India. So over and above all the foreign direct investment norms, we had to go and obtain change control approvals because there was a global change occurring. Uh, and it's and sometimes this is really missed out. And amongst other approvals, the process in India is very clear. It's a prior approval, and if you complete a global transaction without this approval, you're non-compliant. You would run a risk. Again, if it's a listed company that's involved directly or indirectly in India in a global transaction, you could potentially be triggering disclosure requirements or a mandatory tender offer requirements for up to 26% of the public shareholders. So in India, we don't have it to the entire remaining shareholders, but we have it for up to 26% of the public shareholders. There would also be disclosure requirements. There could be interest implications if you delayed your open offer and or your offer price would be determined in a certain manner. You would have flexibility to create escrows specific to such transactions. So there are quite a few approvals that could become applicable both from a Reserve Bank and Securities Exchange Board of India perspective, depending on who's your regulator. It could also be other regulators like IRDA, banking, Reserve Bank's banking divisions. So depending on which sector it is, in addition to your general sector related conditions and approval, one must analyze and clearly check whether all of that has been completed in case there is a legacy investment or a legacy transaction. And lastly, I will just give one more example that whenever you're acquiring a financial services business in India, be it non-banking or otherwise, there is a change control if you're crossing a threshold or even changing directors beyond 33%. So that's also there's one thing that one needs to keep in mind, really. Over to you, Samir.
Thank you very much, Moin. And what I'd like to do now is bring in Ashutosh. And Ashutosh, we've spoken about, Karun spoke about structures, Moin has spoken about the policy in general. But when it comes down to the actual nuts and bolts of fixing a transaction and the structure, what are the, what maybe some of the points that we haven't discussed thus far that you'd like to talk about in your experience?
Sure, Samir. So I think we have touched on most of the important points, but I just wanted to, speak more about, how FEMA sort of influences deal structuring, right? I mean, because it's the primary law at the end of the day, which specifies, who can invest, how much can they invest, at what rate, and what instruments and stuff like that. So, like, generally speaking, you would have the first aspect which will impact the deal structuring is the sector, essentially, whether it is a regulated sector, whether it is a fully permitted investment sector, or is there any restriction around it. To give you an example, for instance, insurance used to be a regulated sector earlier. There was only 49% for investment permitted, and there you would have seen a number of JVs where foreign investors would come in, hold 51%, with the Indian partner holding 51% and the majority. And then then in 2021 we changed it. It became 74%, and then suddenly you saw a lot of flips. Future Generali is one of the examples where Generali basically went up and acquired 74%. And another sector is pharma, where although 100% investment is permitted, but if you're acquiring a existing company, which is called a brownfield sector, as such brownfield investment, then you need to take government permission for acquiring more than 74%. So up to 74 you can do automatic, and after that you'll have to go to the DOP and get their permission. So sector, which sector you're investing in, it's extremely important to see what the FEMA prescribes is the investment limit and the investment mechanism for that sector is. Then there comes pricing guidelines. At what price are you investing in? Pricing guidelines are also extremely important. What FEMA prescribes is that a foreign investor cannot acquire Indian shares at a price which is lower than the fair market value. Right, so and that fair market value is determined by an internationally accepted pricing methodology. Usually, it's discounted cash flow. That's what you see in market mostly. At the time of exit, again, this fair market value concept comes in. You cannot sell for a price which is above the fair market value at that point in time, right? For foreign investors. So this also, pricing guidelines along with your sector plays a very important role. Then there are terms like, while you can have a put option where, foreign investor can ask the Indian promoters to buy a foreign investor out, but it cannot provide a guaranteed return, right? That restriction is also there. So no guaranteed return can be promised to a foreign investor. And we have seen this. We have seen this in the famously in NTT Docomo versus Tata Sons case, right? Where Docomo had to jump through hoops, right? The treatment went through a large legal battle. There was arbitration involved, and then we had to help them get the money through Delhi High Court orders. So the FEMA does impact, and FEMA has significant restrictions, which one has to keep in mind while doing structuring for a cross-border transaction. And Moin spoke about merger regulations, right? So while cross-border mergers are now permitted, but that also need to be kind of aligned with otherwise what is otherwise permitted in FEMA. For instance, if you need to be aligned with pricing guidelines, the sectoral caps will have to be followed. You cannot hold assets which you are otherwise not permitted to hold under FDI or ODI route. And even the deemed approval mechanism will come in only if you're qualifying and you're fulfilling all the other conditions. Otherwise, you'll have to go and seek permission for doing these mergers, like Moin mentioned. So yeah, I mean, in summary, essentially, FEMA does impact, and it is a good practice to kind of keep all of these things in mind, whether it is the sector, whether it is the pricing guideline, whether it is the terms of investment that you're doing, whether it's terms of coming in or terms of going out, both sides. So yes, I mean that's I think that's about it from my side on this.
Great. And what I'd like to now do, and now we're now entering the final quadrant of our panel discussion. And what we noticed was that in the lead up to the webinar, a lot of the registration questions were around risk mitigation and what are the strategies we would use. So what I will do is Ashutosh and Karun start thinking about it. I will come back to you on that issue. But Ritu, why don't I invite you to talk about when we talk about deferred considerations and earnouts? How does that work from an Indian tax perspective? And Ashutosh and Karun, I'll come back to you with a more broader question on risk mitigation.
Sure. Thanks, Samir. So earnouts or milestone-based payments, deferred consideration constructs, I think there are generally very good business or commercial reasons for such structures. You don't want to commit to the valuation upfront. Buyer would want to see how the valuations play out, etc., and then remunerate the sellers. But there are certain tax nuances because income tax law doesn't currently have a specific provision dealing with taxability of deferred consideration. And for the seller, the key tax issue is that while you're deferring the consideration, is the taxability also deferred? And the answer to that is gray. Based on certain interpretation issues and the provisions of law, one position is that when you sell a capital asset or shares, then the consideration is taxable in the year of transfer of the asset. So taxability cannot be deferred even if some part of consideration is flowing to the seller in later years. But today we have certain favorable court rulings where courts have decided in favor of sellers, supporting the position that sellers shouldn't be taxed until and unless they have actually earned additional consideration where the consideration is subject to satisfaction of conditions. So unless those conditions are satisfied and income is actually accruing to the sellers shouldn't be required to pay any taxes. So sellers could rely on this position, but again, this is not a ruling from Supreme Court yet. Law is still gray. So it's a case law driven position, not that it is final and it's not exposed to any challenges. From a buyer perspective, the key issue is in the context of its withholding tax obligation. So if you have a non-resident seller, buyer under law is required to withhold applicable tax which is payable by the sellers upfront when the consideration is paid to the sellers. Any non-compliance exposes the buyer to India tax risks. So buyers would generally want to be conservative. They wouldn't want to take any risks. And if, let's say, subject to how the negotiations play out, if, let's say, buyer is willing to accommodate the sellers, then that will be basis a robust set of reps, warranties, indemnities, so that tomorrow if buyer has a tax challenge, buyer can rely on the contractual comfort. Some alternate positions that we see, sometimes sellers do take a position that they will pay tax as and when they receive the contingent payouts, but they will pay the tax with interest, treating it as income relating to the year in which the transaction took place. So that's sort of a more balanced approach where, yes, you're not going out of pocket on day one when you're selling the asset. You're paying taxes only when there's certainty that you're earning income, but you pay interest for the interim period. Generally, we see these earnouts spanning over 2 to 3 years, not a long period of time. So in terms of interest cost, one can do that quantification to see how substantial the interest element could be. And the alternate structures which are generally discussed, deliberated in these arrangements because deferred consideration taxability is unclear, are, let's say, where such payouts are structured in the form of service fee or employment income for the sellers, where sellers are individuals and they are on the payroll of the target company. Just that the key downside is that the tax rates applicable on a service fee or employment income are high compared to what it is for a capital gain income. But there will be certainty as to when you are required to pay taxes. Or you tranche the sale itself, sell the shares in tranches where it is okay from a commercial perspective, so that consideration allocated to the respective tranches is taxable as and when those shares are sold. So no one size fits all. It's all a mix of commercial, tax, legal considerations that one should think through before deciding on the right structure for structuring deferred payouts.
Fantastic. And maybe then I think it's important we move on to the larger point of risk allocation mechanisms. And while ordinarily one would expect these are the subject matter of bargaining positions, and in fact, factual scenarios of each transaction differ. But on several occasions, we as Indian practitioners see our hand is forced by these exchange control norms. So, Karun, Ashutosh, and I know it's a question both of you can spend an entire hour on, but if I have to ask you both to pick on three topics each, when it comes to risk mitigation, warranties, indemnities, what are the different nuances that we need to deal with when it comes to these cross-border matters?
No, it's a great question, Samir. Look, I think you've got to understand there are competing elements in a buyer and a seller. The seller wants to walk away with all the considerations scot-free without any sort of clawbacks, without any risk allocated to that funds that he's received, whereas the buyer does not want to acquire an entity and be liable for the so-called faults of the seller going forward. So one of the ways in which you try to contain or you allocate risks is by negotiating in your share purchase agreement indemnities. Now, what exactly is an indemnity? It's a contractual remedy and risk allocation mechanism that the parties to an M&A transaction negotiate before in order to address certain post-closing issues and potential losses. So some of the main elements of indemnities are, fundamental indemnities, based on what your fundamental reps and warranties will be. And these go to authority, capacity, title. If I'm acquiring shares, I want to be absolutely certain that these shares are 100% clean and there's no sort of risk as far as title is concerned. Then there's the element of business indemnities, business related based on the business that you're entering into. So you have certain allocations of business risks that you put in the indemnity provisions. Sometimes when you're doing a real estate or if you're buying a manufacturing unit which is based on or located over real estate, you want to make sure that there's certain title with respect to the land also. So you'll have certain indemnities in relation to real estate. There's tax, and Ritu has already addressed some of the tax considerations. And then, Ashutosh mentioned some of the steps that you do in an M&A transaction, including undertaking diligence. If there are certain specific items that are called out from diligence, you want to identify them also as a specific indemnity item. Now, over and above the indemnity provisions, you've got to also understand that, once money is transferred by a purchaser to the seller, then essentially the money is transferred. It's already gone. You have to actually undertake certain processes, as will be enshrined in your SPA, in order to get that money back. There are certain other mechanisms that you can use, such as an escrow mechanism. And what does this entail? It basically entails you withhold some of the amount, some of the consideration, you put it in an independent third-party agency's account for the duration until certain conditions are met with, until certain sort of pre-agreed milestones have passed. Then those monies will be released to the selling shareholder. Now, the practical risks of managing an escrow account is, one, you need to find a reputable escrow agent. Second, you need to negotiate your escrow agreement, and then you'll have agreed claims notices, agreed release date notices. So all of this there's a lot of tension there between the buyers, sellers, and also the escrow agent, as you know, an independent third party is also caught in the middle. So they want to make sure that there's absolutely no liability that attaches to them, you know, for any sort of breach, so to speak. The other element that we've seen acquirers use is holdbacks. Now, a holdback is also something where it's similar to an escrow. You withhold certain amounts, certain consideration amounts. The buyer basically keeps it with them until, again, certain milestones, certain pre-agreed sort of conditions are met. And this is another sort of way in which, of course, it depends on whether the seller is comfortable with the buyer retaining these amounts or whether they prefer to have it in an escrow agency's account. And the last but more interesting methodology to mitigate risks in M&A is tranced acquisitions. So you acquire a certain portion, you allow the sellers to have sufficient skin in the game. You look at the company or the target over 2 or 3 audit cycles. Then you have the element of a kicker also that you can give to the sellers. Obviously, if the company does well, there's value accretion. So the buyer has to be aware that there could be an increase in the purchase consideration. So these are some of the methodologies that we've used in some of our transactions. But again, a lot of time, effort, energy is spent in these as well.
Oh yes,
Go
I
ahead,
mean, I just add on to what Karun said and fully agree with him. There's a lot of energy and time spent on these things, but it's important to link the diligence with risk allocation as well, right? And that's where specific indemnity, the concept of specific indemnities come in. Which essentially means that if you have found something in diligence, the risk related to that needs to be allocated to the parties, right? Who's going to bear how much of that risk? Because you don't want unknown risk to turn into an unknown consequence later on, right? So that's one important example. Like an unresolved tax matter. I mean, that's sort of very, very common specific indemnity that you will see, right? I mean, an unresolved tax litigation is going on, and you would want to kind of include it as a specific indemnity matter. And what that means is, if any risk were to come out of that, if eventually the tax matter gets resolved unfavorably, then the risk will be borne by the seller at that point in time, and they will have to indemnify the buyer for it. There are other mechanisms, like Karun mentioned. There's deferred consideration. There's an escrow. Although you'll have to be mindful of the FEMA regulations around it. You cannot defer indefinite amount of consideration for indefinite amount of time. There's a prescription. There's a limit of 25% of the consideration that can be deferred, only for 18 months. Not anything beyond that. So you can do that, sort of a holdback where you can defer the consideration for 25% of the consideration for 18 months. It gives you that a little bit of leeway to kind of say that, if, say, for instance, if there's a contract which needs to be kind of entered into with a vendor, or contract needs to be renewed, you could just hold back a little bit of consideration and say that, just this needs to be completed before I release this to you, or an indemnity claim which is to come in. You could say that, I'm going to hold this much in my escrow for this claim, and if this claim comes within 18 months, then I will be able to kind of take the money from this escrow out to satisfy the indemnity claim. Another thing that I feel often gets overlooked is the precise drafting. Precise drafting is very, very important. Because you don't want to end up in a scenario where there is a dispute around the interpretation of what warranty particularly means, or what a clause is intended to be. a very easy example of it is, a warranty which usually everyone would have seen that, we are in compliance with all applicable laws. It's quite a quite a wide warranty as such. And then you would want to kind of qualify it by saying that something which is reasonable, something which is applicable to it, all material applicable laws, for instance, so that smaller sort of breaches are not caught in it. Even direct, the usage of words direct and indirect is very important in the placement of these words. So precise drafting is key, should be paid good attention to. I also wanted to talk about WNI insurance as one of the risk mitigation strategies that is coming in now. Because about a decade back, India did not have a WNI insurance concept as such, right? But you would see this is common practice in more mature jurisdictions where insurer will step in and cover a seller for any warranty breaches. Right, it gives peace of mind to the buyer as well, that there is an entity of substance, an insurer, third party coming in, going to cover me in case I suffer any unseen, unforeseeable risks per se. And the seller is also, okay, I'm now done with the deal. I've signed the deal, and there is someone else who's going to step in and cover for me in case there is a claim which comes out of it. It is a new concept for India, but it's picking up. It's picking up really, really fast. You see insurers doing it now. Insurers are also waking up to this business as such, and a lot of PE exits. And these deals, you will see that WNI insurance is sort of norm now. And hopefully, going forward also, these sort of risk mitigation strategies will be adopted for mid market and other deals as well. So yeah, that's over. Back to you, Samir.
Thank you very much, Ashutosh and Karun. And I must say we are already over time. I thought it was a very engaging discussion. But there are two questions I do want to pick up from the audience Q&A. Why don't I start with you, Moin? Because I think there's a lot of Q&A on PN3. And in
Right.
particular, I'll read two different questions that we've received and feel free to address it. So first is obviously, are approvals really forthcoming? What is the kind of timeline we're looking at? And the second is a very interesting piece, which is that when you're evaluating PN3, does the government also consider intermediate entities? So the example they've given is, let's say there's UK at the top, there's, let's say, Hong Kong in between, then there is an India. How does that play out? So I'd love to hear your thoughts on that.
Thanks. Thanks, Amit. I think both are very interesting questions. So, on whether approvals are forthcoming, yes, they are forthcoming. We've got it across industries. We've got about 3 dozen approvals as a firm. We've only seen success, fortunately. We've not seen an unsuccessful approval. But obviously, there's a lot of groundwork that we put into before we proceed. Uh, there have been instances where clients have not been forthcoming with information and therefore withdrawals have happened, especially in the cases when there's a substantial holding by state-owned enterprises. More traction is being seen in the financial services sector, pharma sector generally, and for investments through Hong Kong or entities being in that region. One of the related questions which you asked, and before I go to the timeline, I'll answer that as well. That as soon as there is an entity in the structure which is from a bordering nation, whether it is the ultimate holdco, whether it's an interim holdco, whether it's a pass-through entity, you still need an approval. Your timeline, your process might be easier, but you need an approval. And those are the ones when I said Hong Kong, the interim Hong Kong structures we are seeing a faster timeline. Now, that being said, there isn't a very consistent timeline. So I'll just talk about the life cycle. When we started these approval applications in 2020, our timeline was almost about a year and sometimes slightly more. It then went to somewhere between 6 to 8 months. And now it's somewhere in the range again of 6 to 8 months, but sometimes slightly less than 6 months, depending on whether it's just an interim entity, whether it's a large private equity fund involved, which is otherwise globally investing, whether there are SOEs or state-owned enterprises, very focused government-owned business, sensitive sector, whether they should consider this, and there are other ministries involved, time taken slightly more. Another element we've seen is that because there are so many deals that have happened over the last 4.5, 5 years, that there are instances where there could be a past non-compliance or a past trigger because there is no threshold. The market initially thought 25, then the market said it's someone said it's 10. So there is no real threshold prescribed. So in global deals there are different views people have taken across the market, and therefore those kind of transactions take some time because post facto approval is required. There's more thinking, and then there's a settlement process undertaken, a compounding process that's required to be undertaken with Reserve Bank. So I think to sum up, timeline inconsistent, but range is 6 to 8 months right now, unless it's very exotic. And whether you are interim or whether you are genuinely the holder or whether you're just a pass through, as long as you're from the bordering nation and somewhere in the structure before you come to India, you need to go and approach for an
Fantastic. Last question, Karun, this is to you. We are living in a world of sanctions. So if, let's say, new sanctions are introduced, how do they affect ongoing transactions? And then we'll probably sum up the webinar.
That's a great question, Samir. Look, sanctions are a very, very important element when acquirers are looking at acquiring assets, right? So there's the sanctions regulations generally recognize the concept of successor liability, which essentially means that if I as an acquirer acquire an entity and that entity is in violation of sanctions laws, then I as the acquirer will be held liable. So from an acquirer's perspective, it's super important to understand the business activities that attract sanctions in the target. And diligence, as Ashutosh mentioned, is one of those areas where we determine if there's any sanctions activity undertaken at the target. If there is a change in law whereby certain activities, attract sanctions, during the midst of a cross-border transaction, then that could potentially derail the transaction because, look, at the end of the day, there's a business case for every acquisition. Now, if the sanctions regulations, sort of become more serious than the business case, then why should I, as an acquirer, take that risk? So there may be other structuring aspects that we need to consider, such as hiving off those particular businesses or those particular businesses that attract sanctions. Those are, they'll delay the sort of timeline. Obviously, we need to understand the full nature of how much revenue has been generated from that sanctions activity for the previous, last 3, 4, 5 financial years. And that's one element also that, especially international counsel take a lot of time kicking the tires on this particular question. So I don't know if I've answered your question, but bottom line is that it's taken very seriously. It could potentially delay the transaction, or if not, derail the transaction, and needs to be considered holistically from the acquirer's lens.
Great. I'm sorry, we've overshot time significantly. So with that, what we'll do is we'll call the webinar to a close. And before we conclude, we would like to ask each of you to respond to the poll. The slide should be on your screen any moment now. Great. So with that, thank you to everyone who participated in the poll. And of course, many, many thanks to all of our panelists for sharing their expertise and experience with us today. I thought that was an outstanding discussion, and we've given hopefully a lot of food for thought. I must apologize to the audience. There were far too many questions. We've not been able to deal with many of those. Some of those were covered in the panel, but we will ensure we respond offline after the webinar. And we will also separately send across today's a summary of today's discussion and a link to the webinar recording. We will also request you to address a feedback form. It's a very short, crisp form, takes less than a minute, but it's very important from our ongoing development perspective. In fact, this entire M&A Academy program is the result of feedback given by participants in some of our other programs. So please feel free to send across any and all sorts of comments and feedback. If there is interest in maybe more bespoke training for your organization, we'd be happy to connect with you after the webinar. Our contact details are on the slide in front of you. With that, thank you very much, ladies and gentlemen.